raising measures, that is the day that we should be ceased of the finance bill or a legislative proposal which would then actualize the revenue raising measures, which then would be the finance bill introduced by committee of finance committee in National Assembly. That was not followed, and there is no justification in my view. And I said as much. I think the House Business Committee let us down. And so, as the Speaker had made a ruling earlier that matters of law can be raised at any time, I believe that this needs to be corrected. We still have a few days to 30th of June, but we need to do things the right way.
All right, we need to do things the right way. We shall hear what you had to say more robustly from that particular press conference that you had in Parliament. Let's hear from Danson Mugatana. Again, I just wanted to raise the issue of Shakahola because you're the ad hoc chair of the committee. So far, we've seen Parliament's, or not really Parliament, but actually the CS Interior, Kindiki, mentioning that now that particular exercise is tapering down, and the graveyard diggers also, they're having issues regarding also the affairs and the payment as well. We have the evangelical ladies and the clergies also really complaining that they should not be painted or painted in a bad corner regarding this particular issue, Shakahola. You had them on Friday, and they are saying, can you just give them the leeway to self-regulate? They will do that instead of the government really also interfering with the affairs of the church. What is the update? What is the latest from the committee?
Well, first I want to thank you for inviting me. For me, I would start by saying this was not a very happy weekend for us in Tana River. We lost one of our MCAs from UDA, who was my friend, and we really worked for him during the campaigns. And he is actually the chair of the finance committee of the assembly. A very good man. So Honorable Ndoeni, we were with the family over the weekend, just came back last night. It was sad because he was very beloved and possibly a future leader for our MPs, future MP or future senator, I don't know. But it was a sad weekend for us, and we're still in that mood. Aside from that, the Shakahola issues, like I've said before, Senate is listening, and we have created an avenue for people to air all their views. And we have had diverse views.
Yes.
And so far, I think, yes, the evangelicals have said they want self-regulations. The Catholic bishops, they have said the same thing. The Muslim Supkem, they have said the same thing. But we also have had different opinion from other groups that believe that it is time for government to really stamp its authority on these matters. So we are balancing, because there is that opinion, and there is also the idea that the Constitution gives us the freedom of worship. So in Shakahola, we are still at that stage of continuing to receive opinions, and we want to listen to everyone. We still have a few, 45 more days to go, because our mandate was limited to 90 days. We are listening even after this. At 9 o'clock, we'll be back there on action again to listen. We are listening to a lot of diverse opinions. So yes, everybody's opinion is welcome. We will make our recommendation, and we hope one way or the other we will contain the misuse of religion by certain people to benefit or even harm public safety. So that's where we are with the Shakahola.
Fantastic.
Yes.
Right, thank you so much. And of course, also there's the issue of MCS with their salary rouse. I think the SRC was trying to raise their salary by the amount of 10,000 shillings.
Yes.
Which now they're really contesting.
There's a problem, because you see, you can't do some of these things without consultations. So the county, we as a Senate believe that we need to look at those benefits again. And we are glad the SRC, after pressure, they are responding. But you see, the way they did it, the way they are doing it, the County Assemblies Forum is saying, you need to engage us so that you actually know what is it. You cannot evaluate someone's job without really talking to them. So there's a bit of a problem there. I see they are responding, but there's a problem. I wish, that's why sometimes I argue, some of these positions, people with political background, they help a lot. Because I know if there was a chair who was having something political, maybe at some point he was an MP, or at some point she was a minister or something, they have this ear for public participation. But when you have bureaucrats sometimes heading these critical organizations, you can make serious blunders. So for me, yes, there's a response, which is a good thing, but we are having an issue because the forum for members of county assembly are still not happy. Why? Because they feel they have not been engaged as they should. I met my speaker yesterday, and he was raising the same issue.
Yes.
That we need to have proper engagement. Okay, so that the problem can be resolved in a manner that is acceptable to all parties. You don't have to actually give me what I want, but give me an opportunity to be heard. That's what they are saying. Yeah, so I hope they will resolve it.
All right, so the issue also of the devolution bond that the governors are seeking on how they can make sure that the government is held to account as far as also disbursing
and
this
we
fund.
are supporting it, by the way. The devolution bond, we senators and governors had a retreat this weekend. Well, not weekend, but Friday. And we were discussing, why is it that exchequer releases are so delayed for our counties, such that county governments have to go and borrow and therefore have to pay interest and commercial rates. And yet, you know, the government was able to work out something and create the infrastructure bond, so that it is easier to finance some of the infrastructure. Why not now create the devolution bond, so that you know, county governments are able to function, pay salary, do their things on time, even when the exchequer releases are delayed. So these are questions that we have agreed as senators and governors, that we are going to engage together, work together to make our counties effective. Because for us, whether you are a senator or governor,
yes,
you know, our business is to make these counties work, because we have seen what they can do. Of course, we have a lot of shortfalls in our county government, but we have seen that they have also made a big change within the last 10 years of their existence. We want to support them. So we are together on that. In fact, we read a joint communique in Naivasha when we finished our meetings. So we hope the Treasury will listen to us. We are also saying that we need the Ministry of Finance to be separated from the Treasury, so that the Treasury should not be run by the Minister, the CS for Finance. Because if he's from the national government, he's going to favor national government allocations as opposed to the county governments. You know, we need the national Treasury to be free of control from the cabinet secretary, so that when our monies are ready for counties, they are made available.
Thank you.
Not the way it is right now.
Indeed, and we shall broach that issue much later. But I want just to dwell on where Mbadi began on Friday regarding the budget estimates and also the finance bill. Seems that we have jumped the gun according to ODM. This should have been actually read concurrently according to the Public Finance Management Act. So let's hear what he had to say, John Bernie, on Friday.
It is anticipated in law that debate on the bill, and indeed any voting, would have succeeded the budget highlights by the CS. Therefore, the budget highlights should precede the debate on the finance bill. On the same date, when the cabinet secretary is reading budget highlights and revenue-raising measures, that is the date that the finance bill setting out the revenue-raising measures shall also be tabled before the August House. After all, Kenya Kwanza claims to have the numbers. What was there to fear? Why rush to actions that are outside the law? That there was negligence on their part? That they have treated Kenyans to some circus? And that Kenyans' time has been wasted. Look, remember, on Wednesday, the whole day, I was not around here, but I observed that the whole day, the National Assembly of Kenya discussed on the legality.
All right, that was John Barry on Friday. John, I throw it to you to just elucidate more on what this really means so far. And now that you're moving to the court, what does it portend for the entire budget reading? It would seem to have jumped that particular junction as it is and crossed the Rubicon. So how will we go back even with you going to court?
I really don't know where you're getting the idea that you're going to court or you're going to court. I'm not aware that a decision has been made yet.
This is according to most of the publications that I've seen. They're claiming that.
Maybe they're going to court or we will go to court. But I think where we are is still early to talk about judicial process. Because this is something that is still before Parliament, still before National Assembly. We just purportedly concluded second reading of the bill. The bill has to go through the Committee of the Whole House and the third reading. My reading of the law is that this is not a finance bill. The finance bill contemplated in law is one where after the Cabinet Secretary has read the budget highlights or the day he's reading the budget highlights and revenue raising measures, then he also submits. In fact, the words used in law is that he submits on that day the legislative proposal. It may not be in a bill. But then the moment, then you go to section 4 or subsection 4 or section 40, which now spells out that the finance committee, it says a committee of parliament or of National Assembly shall then introduce a finance bill to the House. So if you introduce a legislative proposal or a finance bill before the day or the date of reading of the highlights, then it cannot be finance bill. It is maybe some government paper that is being discussed, but you can't call it finance bill. So in my view, and this I think is Speaker Marendi who made the ruling, and has been carried over the period, that a bill, you can raise issues of constitutionality or legality at any stage. So it still can be salvaged, and we still have days. I've had people say that we want to have finance bill quickly so that we can have appropriation bill. Fine, Parliament has a way of transacting business or dealing with issues of which are urgent. One of which is to request the same Parliament to reduce publication period even to a day. So the finance bill can still be introduced in Parliament this week, debated as it should be, through and goes through second reading before finally getting to the Committee of the Whole House. So my position is that this is something that still needs to be salvaged, because otherwise what we will do is for the first time pass an illegal Finance Act for 2023.
So we'll pass an illegality according to your estimation. Right, Gladys Bosu-Shole, this was actually raised during the debate on the floor of the House by the Member of Parliament of Rarieda, right? Because he was saying there's a violation of the PFM Act, and it seems also the Speaker did not give him insufficient time to elucidate this particular matter, and according to him as well, there was no violation of the standing orders. You're in the House.
Yes, I think I'm going to defer that to my colleague.
Oh, yeah.
You know, we make a joke. We call him the Constitution of Parliament because he has more institutional memory than all of us.
Yes. So was there any violation of the standing orders?
I think yes. I do agree that there were certain oversights. I mean, they are exactly as the chair of PAC is talking about. That should have been ready and immediately handed over. Now, my position is that the independence, unfettered independence of Parliament is such that you can never take Parliament to court. Parliament has the powers and the independence to pass, including unconstitutional bills. Only when it comes before you in a court of law is when you say this is not constitutional, so let Parliament go and make a provision for this. But for Parliament to try and interfere with the workings of the House, anybody can go to court. I actually was not very happy on a number of occasions when somebody, there is something called sub judice. The idea of a sub judice is that if a matter is alive in court, then you cannot introduce that matter in Parliament. You see what I mean? You allow the court to have its own, basically, you can't introduce that, because then you will try and affect the decision of the court, the independence of the court itself. In the same way, the courts cannot interfere with what is in Parliament. They can't. He's a lawyer, she's a lawyer, I'm a lawyer, and you can't interfere with that. So when this business of saying that Omtata is going to go run to the courts and the rest of it, as far as I'm concerned, is hogwash. It's not there. 100 of them can rush into the courts.
He's also a member of parliament.
It doesn't matter, even if he's not a member of parliament, he can even be the president, you know what I mean, of the country. You can't go to court to try and gag parliament or stop parliament from transacting parliamentary business. That's why you call the independence of each one of them. The independence of parliament basically means parliament is independent. The very what you call celebrated case of Madison vs. Marbury. If you read that and you get to understand it, and there was also a very powerful celebrated case in law when the court in the UK only say Parliament should make a law for that. You know what I mean? The court cannot go castigate and say that if there's a lacuna, Parliament will do that. You can only say that there's a lacuna in this, but courts cannot instruct Parliament on how Parliament can transact its business. I think this is one area that everybody should know. I think there's a total misunderstanding of these things, and it's widespread, including the government being worried somebody's going to court to do what? To try and gag Parliament? To go even and gag what you call the executive? You can only do it in corroboration if a matter appears before the court itself and the judges itself. And then you can say the constitution is unconstitutional. A matter is brought to court over a decision that is taken another place on the constitutionality, or whether the administrative law itself was followed, or whatever it is, illegality, when somebody brings that matter to court. But you can't stop Parliament from transacting parliamentary business. It's unfettered, it is independent, even if it's unconstitutional. When a matter is brought to you on the same thing is when the courts can say this thing is unconstitutional.
And I think Dibala, I think he brings a very important point here, is that we've reached a point in Kenya where the courts have become a playground for anybody who wants to stop any business in the country from going on. And I think it's sad to see that the judiciary has agreed to be used as such. Because we've seen cases being taken to court that have not even, there is no cause of action. Nothing has even begun to happen in Parliament. Nothing has even been transacted by Parliament. But in anticipation, because of somebody speculating that something might happen, they take a speculation to court. And the court has the audacity to even entertain it. So when you talk about the courts being, having a huge backlog, it's because they take cases that should not be there. First of all, you have cases being taken by a member of Parliament who has the ability to be able to lobby his colleagues. He has the ability to be able to vote on a matter, but before he votes on it, he goes to court. It is something we must start interrogating as a country. It is wrong. And we cannot go that way. It means we can never do anything. So when somebody says that, like even there were cases were taken to court, Parliament had not even begun its work on that matter, yet somebody has already gone to court. Why did the court allow that case to even be logged in the court system? The court can clearly, the first judge or magistrate who hears the case should say there's no cause of action. That's the first thing. There's no cause of action yet. So bring it when there's a cause of action. But the courts have become, they've been held ransom by people. Because if the courts don't take that brave decision, they'll just keep saying we have 100,000 cases pending in court. Half of them should not even be in court in the first place. So it is something we must begin to interrogate. All this money that we are going to go give the judiciary, we do not want the judiciary to be getting more money just to entertain cases that should not be before them. Yes.
So you hold the same view as well, Nelson Mugatana?
Yeah, because it's a legal position. But I think the point the Honorable Mbadi is making is that procedure, according to his interpretation, was not followed. And the question is, and I think if they should go to court, the question would be, is it so bad that it would affect the eventual results? Because in court, there's also the rule of de minimis. If an issue is not that critical, it's small, then it can't affect the final result of whatever the judgment would be. So for me, he raises a point, and maybe we need to look at how we need to do things. But if I say I'm tabling the bill today as I read the proposals that I make for revenue raising, and I table it one day, what's the difference? Maybe the rules say I should table it, but what's the big issue, you know? So, but it's good, you know. What I like about this is that opposition must play its role. If they feel there's an issue, they must raise it. But as to whether those issues are all very critical, that's another question. For me, this is not a big issue. I think the real thing is for them now to focus on the committee of the whole. They should go make their arguments, and we have the numbers. I believe that most of the proposals that the government has through the finance committee would pass, but they must stand there and say their bit. What I don't like is the fact that some of their own people were absent in the debate. This is a very sad thing. It doesn't matter whether you are losing or you are winning. The thing is, stand and say what you think should happen from your personal point of view or your political party's point of view. So they should go through the process, say their bit, and maybe negotiate. There are some things maybe they could be negotiated if it is doable. But say your part, and let the voice of the majority carry the day. But your voice must be heard. So I believe this is part of what they are doing. But for me, it is not a very critical issue that can affect. In fact, what the courts would do in the event that they go to court, they will say, is it unconstitutional? You know, for an act of parliament to be struck out as unconstitutional, the standards are not the normal standards. You can't just say, on a balance of probability, this act is unconstitutional, so you struck it out. It's higher than that. The court would be more keen. So on this one, can we say because the proposals, the bill was passed one day before, it is unconstitutional, it is so bad that it has to be struck out, all of it? I'm not persuaded. So for me, I think he was doing a good job. It's his role, but I don't believe that it's critical.
It's critical.
Can I just say something before?
No, let's hear from
Mbadi. I just to enrich Mbadi.
Okay.
Mbadi put it very well. Parliament has got its own internal mechanisms to correct its own mistakes. Simple. The independence is in the House itself. With their lapses, if this issue is raised, I am sure it's raised in the floor of the House. The Speaker is going to seek more time. We'll go back. We have no problem with the Speaker saying that the initial ruling itself was not right, not correct one, and this is the ruling, and give a ruling again and the way forward. So Parliament is an independent institution that is able, has an internal mechanism for it, even if something doesn't go right, to correct itself. But for another arm of the government to get involved, you know, this, I don't know why Parliament does not, courts do not even have the right to direct the president what to do. You see what I mean? That is the centerpiece of the Marbury versus Madison. Yes, justice of peace, you have a right. Yes, this and that. Yes, but the courts cannot direct the president. You understand my point? The courts cannot tell the president you must act in this or that fashion. For example, when he refused to sign into those judges and the rest of them, no courts can. And the same courts to pretend to direct the president to proceed and give that, in my opinion, is erroneous.
Thank you. Let's hear from John Mbadi.
Yeah.
And as she has put it, the courts is a place that needs to
Thank you, Farah.
The right mental, intellectual disposition must be there present. There's
Thank
a
you.
lot of jokings there.
Thank you. Mbadi, on this as well, I just wanted to know, why did you find it also astounding that the Speaker while seated there, mentioned that this is not a violation of the standing orders, as it were. So you mentioned, Farum Alim, that there was a violation. So what can you get
of the practice?
Of the practice, yes. So
which is equally as good as the standing orders. When you have a practice and the president is there,
he seemed not really bat an eyelid when he was saying this. So it's really astounding. Let's hear from John.
Proceed and listen first.
Thank you. I want to first start with the issue of separation of powers. And I want to largely agree with my colleagues that I think it's deliberate that we have separated powers to the three arms, of given different responsibility to the three arms of government. And we have even created a fourth one, which is the commissions, which I don't know whether they are effective as we expected or envisaged. And I hold the view that when the executive is doing its work, we should let the executive do its work to conclusion. If we have issues, Parliament as an oversighting body should look at what the implementation by the executive and fault it. But we cannot participate or purport to participate in the implementation of programs. That is why sometimes I find even committees of our Parliament overreaching, where now you get to the ministers and start directing the most agencies on how they should do their work. What we need to do is to review the policies of government, how they are implemented. If we feel we have a problem with it, we spell out what we think should be done, but not to interfere with the executive. Equally, we should not interfere with the judiciary. But judiciary should also not interfere with the other two arms of government. When a matter is before Parliament, I would expect the judiciary to wait for the Parliament to dispense with the matter. And then now you can go to court and question the product of a legislative proposal. You feel it is unconstitutional, like if we feel the finance bill is unconstitutional and Parliament did not deal with the unconstitutionality or the procedural issues, then now you can now take it to court for interpretation, because that is the role of the judiciary. But before that, exhaust the framework of Parliament. And that is why I said I'm not sure whether we are going to court, because we are not there yet.
You're not there yet.
And in the same vein, I find like courts stopping Azimio Coalition from removing Sabina Chege from deputy whip is also interference with parliamentary process. Let them wait until the Sabina Chege is removed from by Parliament. Then, once the Speaker makes the communication, she can then go to court and cite violation of her rights. And the court would then pronounce itself whether that was procedural or not. If it was not procedural, the court will direct that Parliament should remove her procedural. Advice. In the absence of that, then she still remains the deputy minority. So I agree fully that we need to check the excesses. Dictatorship from any arm of government is dictatorship, whether it is from executive, Parliament, legislature or judiciary. So having said that, on this issue of finance bill, I want to agree with Honorable Mugatana that if the violation is not so material as to affect the outcome, then it should not be entertained or considered. But on this issue of finance bill, I hold a different view. I participated in drafting the Public Finance Management Act. And the reason why we came up with this provision that on the day when the CS is reading the budget highlights and revenue raising measures is the day that we should be seized of a legislative proposal. It was not just an idle provision in law. It is because it is expected that when the CS comes, and I have heard people say that that pronouncement is ceremonial. It cannot be ceremonial when it is provided in law. It is important. And the reason is simple. We have budget policy statement read in February. Between February and towards the end of the year, a lot of changes would have happened. Therefore, it is expected that the executive, before submitting legislative proposal to Parliament, should spell out policies or policy adjustments or policy changes that needs to be factored in the legislative proposal. So you cannot discuss legislative proposal before you hear from government, the official government policy on the way forward in terms of economic fundamentals of the country. And so that is why we placed it after the finance bill, to come after the reading of the budget highlights, so that the CS spells out to Kenyans that this is the direction we want to take. So when you're discussing the finance bill or you're taking it to public participation, it should factor in some of the pronouncements made by the CS. Now, when you bring it early, and you have, well, it is good for public debate. And I think it was good that the government brought in some paper. I call it a government paper, not finance bill, for Kenyans to understand the thinking of government in terms of taxation and all these other issues. But we should respect the provisions of the law. Unless we amend the law, we must access it. Otherwise, I want to stop there and to move to the next topic, or we can continue.
Yes, we'll just continue, but I want just to take a short break right now. So when we circle back, we'll continue with it. Then I want to know, because I can see some of the dailies as well, your faces are being splashed here. Farah Malim, you are no-show during this particular... Yes, we want to know why you are no-show. Yeah, well, no, I'll sort you out with the Wi-Fi, don't worry.
And
yes,
you can ask me,
yes, and also your face also was not seen there.
Yes.
And now we have the party threatening to disciplinary action, right, especially on LDM. You have been also very vocal on this finance bill, but you have, I thought you'll have voted no, but you're not sure. Want to understand why?
Wanted to vote, yes.
You're going to vote yes. Okay, you'll tell us why. We'll take a short break right now. When we circle back, also we shall hear from the speakers panel as well, what is really happening as far as healthy debate on the floor of the House is concerned, right? All the time we can see put up the question being raised, and this has been a concern from some of the legislators that they're not allowed to have a healthy debate on some of these contentious issues or pertinent issues on the floor of the House. We'll take a short break, don't go back.